Go ahead and get started. We're going to reconvene full committee here and want to welcome everybody here again. And what we're going to do is address each one of the provisos that were pulled individually. So now we're going to move to the new amendments, and the first new amendment we have is Amendment 2. So if y'all look on, bring it up. And for those in the audience, let me remind you that while we're not handing out paper copies, obviously the amendments are on the screens there, but better yet, if you can take your mobile device and go to the website, and you can see these amendments contemporaneous with what are occurring, what the membership here is seeing. So the first one amendment is Mr. Gary Smith. You're recognized.
Thank you, Mr. Chairman. One of the things that we did in subcommittee this year is we carried forward the library county funding aid to libraries for the purpose of trying to do some changes and all to that. This is kind of what we have come up with from that. What it does is it takes and adds what was passed, I think, back in the late 90s, which was the South Carolina Comprehensive Health and Safety Act, which the State Department of Education later produced 140 pages of regulations concerning what is appropriate and what's not, and what age is appropriate and so forth for health and safety issues to be shared with children, and to apply that toward our libraries and how they operate also. And that's basically what this does.
Representative Cobb-Hunter.
Thank you, Mr. Chairman. Mr. Smith, you said a lot, but can you just get to the bottom line here? What about the Comprehensive Health and Safety Act are we instructing libraries not to do or to do?
What we're instructing them to do is to apply and to utilize the Health and Safety Act as well as the regulations that have been promulgated by the State Department of Education when they have events and when they have issues that are at their the libraries.
Can you give me an example of what you're talking about?
Sure. As I mentioned earlier, one of the things that is very well covered in the regulations is what's age appropriate and what's not, and that's one of the issues that would be applied.
So now we are about to ask our librarians to be monitors of materials. Are we about to have librarians card people to see if they are old enough to read appropriate materials? I'm trying to get a sense of what the point is.
If you look at what it talks about events and issues or use of their facilities and what's appropriate and what is not.
So okay, so now we're talking not about patrons of the library and their reading and using library. We are talking about outside groups coming in and renting library facilities. Is that what this is about?
That's part of it, yes, ma'am.
Okay, so who determines what's appropriate and what's not appropriate?
That would be up to the library based upon the regulations and based upon the act itself.
And now explain to me these regulations you're talking about. What kind of health and safety? I'm confused about what you're getting at here. Has the library been used in is it your understanding that some of our libraries have been used in ways that are not appropriate, people using the library?
That's certainly a concern.
In what way? Give me an example.
And again, is in relationship to what's appropriate and what's not. As I said, the regulations themselves are 140 pages long, and what was one of the issues that came up this past weekend and having to do with a drag queen story hour at a library in Greenville County was whether or not that was age appropriate, particularly when you look at the age group that the group was looking to target, which was ages 3 to 8 years old.
Shouldn't parents be the judge of, okay, you said some drag queen story at the Greenville Library. Isn't that what you said?
Yes,
Why are
I
people
did.
laughing? I'm trying to understand what the issue is.
Yes, ma'am, I did. I said drag queen story hour.
So I'm just trying to figure out why we are imposing this on libraries when you've got grown people coming into a library. Who are we to say to a library, if this is an event that the library, I'm trying to figure out how we are micromanaging libraries based on the events that some of us may or may not like, but last time I checked, there was freedom of speech and freedom of press, was it not?
There is, that's
So
correct.
why is the library being penalized because somebody had a drag queen contest in the library?
The point is that if it's appropriate for our education system, for dealing with our children, then it should be appropriate also for our libraries in how they utilize the public facilities.
I don't know, Mr. Smith, maybe it's me. Nobody else seems to have a problem with this, but I really think this is way beyond our wheelhouse to now be talking to libraries about monitoring and censoring the kind of events that they have because we don't like the type of event. I really don't understand, and I'm not being facetious. Don't we have enough on our plate to say grace over without messing with libraries? Can't we focus on something that we are supposed to focus on, like fixing our schools? I'm just asking.
I think this is important to deal with.
Okay, Mr. Chairman, I raise a point of order that this is not germane.
All right. And your point of germaneness as to what's your point of germaneness?
My point of germaneness, Mr. Chairman, is that this is not tied directly to any line item in the budget. It grabs and indicates aid to subdivision, but there is no direct tie-in to any line item in our budget.
Yes. Mr. Cobb-Hunter, I'm going to overrule that point of germaneness. The way I see this is that the substantial effect of this bill is as to libraries that receive aid to county or aid to city libraries. There's obviously aid. Both of those are in line items in the budget. In fact, you'll probably maybe see some line items in that regard as we do that.
God help us.
I know. And so as we look at this and the substantial effect is tied to the funding in that regard, so I overrule your point of germaneness.
Thank you, Mr. Chairman, and I was grasping at straws. One last question, Mr. Smith, if I may.
Yes, ma'am.
Were any librarians consulted in the language, developing the language of this? Do we know what effect this might have on the operations of a library if they are now becoming monitors of external activities and events?
Yes, I talked with the.
Other than the Greenville Library?
No, not other than the Greenville Library, no.
Okay. Thank you. Thank you,
Yes,
Mr. Smith. Thank you, Mr. Chairman.
Clyburn?
Mr. Chairman, just want to follow up on that just a little bit more. I want to be clear on this. There were no participation from librarians, Representative Smith. There was any approval, disapproval by librarians?
Yes, sir. There's an approval process for the use of facilities, an application process that they review and vet.
From librarians?
Yes, sir.
And the second piece of that is, that are we saying now if they don't follow according to this proviso that they have to return funds back to the General Assembly? What does it say?
And the proviso that you have in front of you is the one that wasn't supposed to be here. This is not the right one, but because we can't really go back retroactive through the budget, so the January 1, 2020, all that language was removed. So we actually have the wrong proviso here, but that language should not be there.
Mr. Chairman, what about that? If this is not the right proviso, why are we dealing with it?
Point of order, Mr. Clyburn. Why are we dealing with this?
I hear a duet going here.
That's right.
No, it's really not.
We're going to create a new point of order, Mr. Smith. Why are we doing this? So, Unfortunately, Mr. Clyburn,
I object, Mr. Chairman. No.
okay, you object to the new rule. Thank you. So, all right. We got Mr. Rutherford first, Ms. Cobb-Hunter. Mr. Rutherford.
Mr. Smith, tell me again exactly, because as Ms. Cobb-Hunter pointed out, the air is different down here. It's harder for us to hear, so if you
I
could.
understand.
Tell me about what it
Particularly
is
when
that
you
you're
have
trying
things
to
in your
do.
ears where you can't hear.
I couldn't even hear you just then. What'd you say?
I said, particularly when you have things in your ear where you can't hear to begin with.
Absolutely. Well, I had to text the chairman to tell him I had a question, so maybe we can text one another.
So what does that have to do with that thing in your ear?
Well, yeah. It helps me tune out people that aren't saying anything that I want to hear. But either way, I am curious about
It
this.
worked well. Next question.
Tell me about what it is that you're asking the libraries to do.
To adhere to the South Carolina Comprehensive Health and Safety Act and the SDE regulations, State Department of Education regulations that are associated with it.
And by doing so, you're asking them to determine whether something is appropriate or not?
It's in the regulations, and it clearly defines, it's 140 pages, so it goes into a great deal of detail as to what's appropriate and what, particularly for age groups.
Right, so there's no shortage of the big government as it relates to that. Now, you want to apply that big government to libraries, which are public facilities, and ask the librarian to determine whether something is appropriate. For example, at the Richland County Library, we had a discussion about guns. Would that be appropriate?
I would think that it would be, but that's something that they would have to determine based upon the regulations and then what age appropriate and what age group was being targeted for that. But let me point out one thing to you also is that these are public funds that we're talking about, in the application of public funds in a public library that is funded by the state. So I think it's very appropriate.
But, so have you set up, is there a legal defense fund for this proviso with what you're going to cost the state and these libraries when they tell me I can't have a seminar to talk about guns out of this book and they tell me no and I sue them? Who's going to defend these? Because that is clearly First Amendment. And the drag queen that you spoke of, if it's in a book and they want to talk about being a drag queen, you couldn't pay me to go, but if other people want to go and listen to it, that's certainly their First Amendment right. And you're asking a librarian to tell them they can't come. Where is the money going to come to defend this librarian when she says no? Who's paying that cost?
Ms. Rutherford, what I would tell you is that since I believe it's 1998, I have to look back and make sure that this has been in existence in our schools and those regulations been, so it's been through that sort of a process.
You
before.
recognize schools are different, right?
And, well, I recognize that the libraries are very similar to schools
No,
in
sir.
how they actually take and operate and what their intention and what they're trying to take and do.
If you're trying to suggest that because both of them have books, they are similar, they are not. They're not. Libraries themselves can discern.
I understand that, Mr. Rutherford.
So again, don't set up people to get sued and not provide them adequate legal representation and understand how much this is going to cost. I appreciate it because I'm gonna make a good living suing all these libraries to tell anybody no, rather than say, this is only allowed for audiences 18 and over. This is only allowed for audiences less than 10. Libraries have a totally different function than schools do. You recognize that, correct? And in doing so, if you don't, please recognize that there are more amendments to the Constitution than just the second one, that you have the first. And in that First Amendment, in a public space that you rent out to other people, you can't tell me what I get to say. We can't do it at the State House. You can't do it in a library. You can do it in a school because children are different. Libraries ain't. And so I just encourage you, before you cost us a bunch of money, go do your research, because I promise you, you're going to come back and realize I would own the Greenville Library after they told me I could not do something there that is in a book in that very same library that I can't read it. You can't do it. But again, you should just be prepared to pay.
Thank you, Mr. Rutherford, for that dissertation. We really appreciate that. What I would like to take and talk with you about and then answer your questions, and I'll try and take them one by one. Do I think that this is something that would be appropriate for the library? Absolutely, I do, because one of the things that you talked about was children. This is all about children, what's appropriate for children, what's not appropriate for children. And I think that's the crux of the matter here, whether it's in the school or in a public library. That's the issue here. Now, whether you want to go out and take and sue the library is something I guess you would have to take and make a determination to do. But what I would suggest to you, that when you look at that this has been in place for quite some time, I think that that has already been attempted, and I think that it has already sustained that. So I don't have any problem with that at all. But I appreciate the question.
You do see the gentleman, and I can't remember his name, but he has the pictures of aborted fetuses, and he brings them to the State House. And every time he does it, I would hate for my children to see that. They're 8 and 9 years old. I would hate for them to see it. But he has a First Amendment right to stand there with those pictures. Do you agree?
I understand what you're saying. Yes.
No, do you agree?
I understand what you're saying.
I understand that you understand. The question is whether you agree that he has a First Amendment right to stand there with the pictures. If you don't, then I understand what you're saying, and we don't need to continue the conversation, because the Constitution exists to cover all of us, even people we disagree with. And that Constitution is going to say that in a public space, even though I am offended by those pictures, even though my children will be offended, I cannot stop him from standing there with those pictures. And because of that, that same protection covers me when I want to go to the library and read a book that is contained in that library to a group of people. And if we don't agree on that, then as long as you understand that not agreeing means that you're going to have to pay, or this body is going to have to allocate legal defense funds to people that are going to tell people no to reading a book that is contained in the library. Sure. My son reads all kinds of Army books, Vietnam books, World War II books about concentration camps.
Sure.
And I'm trying to explain it to him, what's in there and what he's reading. But it's a book. And if he was to read that book in a library, somebody might find it offensive.
Sure.
But if
And
they
Mr.
did, and the
Rutherford-
librarian said they could not read that book, I would be able to sue.
Mr. Rutherford, we're not talking about books and what books that they're reading. What we're talking about is an event. And if you look at the Drag Queen Storytime Hour, it wasn't about a particular book. It was about a group of men dressed as women coming in to talk with 3 to 8 years old about being transgender and those sorts of issues and what's age appropriate for that. That's an entirely different situation. And I understand what you're saying. I agree with you on that issue about the First Amendment right. I agree with you. That's an important issue to take into to adhere to. But what I would suggest to you, just like going into a crowded building and shouting fire not being appropriate, there's things that are appropriate and there's things that are not appropriate. That is not appropriate, particularly when you're looking to take and target 3 and 8 year olds.
I'm getting new information as you speak. I'm unaware of the Greenville event. But Mr. Smith, if I could ask you.
Sure.
They were targeting
Yes, sir.
3 to 8 year olds. Did those 3 to 8 year olds drive themselves there? Because if they didn't, and their parents took them, their parents determined what was appropriate for them to hear, did they not?
Mr. Rutherford, the issue is not that. The issue is, again, what is appropriate for the library to do with public funds and with state funds. And we have a process, we have a policy in place to deal with that. And as I spoke to, if you heard earlier, my colleague up the road here actually talked to me about and asked me the question. And I appreciate Bill for doing that. Is there a policy for reviewing of these applications for use of the facility? Yes, there is. Is there a process that they use or should be using to take and to vet those? Yes, I understand that there is somewhat. So what this is meant to do is apply exactly what we have done to our schools and what's been deemed appropriate by the General Assembly and by this legislative body to the use of the library for these sorts of events and situations.
Again, I would submit
And
to
I
you.
understand if you may have a problem with that, but
No, sir, it's not me, it's the Constitution. And see,
Well, I don't-
again, my children we were down in Charleston at the Chick-fil-A Express. Didn't even know it existed. There's a Chick-fil-A Express. What makes it an express, it doesn't have a bathroom. The bathroom was across the street in the College of Charleston.
Yeah.
So when I walked down the hallway to the bathroom, my 8-year-old said, "Daddy, there's a picture down there that's not appropriate." And I said, "Well, show it to me, because I want to see it." So we walk out, and sure enough, there's a naked woman at the end of the
I am
hallway.
shocked.
I can show you a picture of it on my
I
phone.
am shocked you wanted to see it.
Because it's what you call art. It's art. And we don't get to determine whether we like it or not, whether people want to see it or not. If you ever go to the Louvre, you see a whole bunch of inappropriate things. And you see a line of people lined up to go see it. Some call it porn, some call it art, some called it porn at the time. Now we consider it to be fine art. Again, the Constitution, the very First Amendment says that you have a right to talk about those things that you want to talk about in a public space. A library is a public space. A school is not, as you will agree, because when you go into a school, you do not have a Fourth Amendment right. You lose a bunch of constitutional rights in a school that you do not lose at a library. You do not lose them at the State House. But if you go into a library, if you go into a school, you have a right. Everything in there belongs to the school. Everything can be searched. Nothing belongs to you. Everything belongs to that school. Schools are different. Libraries are different than schools. The First Amendment, in its application to a public space like a library, is not only different than in schools. And all I'm asking you to do, go back, read the case law, and let's look at this. If you want to do it on the floor. But I promise you, this is a lawyer's dream, and it's going to tie up the libraries, tie up your counties. Anybody that funds these libraries is going to be defending lawsuits as to what's appropriate and what's not. Because a discussion about Picasso's nudes, it's not appropriate for my 8-year-old, but if you want to take yours, so be it. But if they limit it to people over 10, they've done their jobs. Somebody has a problem with that, they can raise it with the library, but the library should not be able to say, according to the Constitution, what they like and what they don't. Especially if Greenville says it's okay and Columbia says it's not. Then you've just opened yourself up for a litany of litigation.
Mr. Rutherford, you're a very astute attorney. I appreciate that very much, but you understand also there's a very much a difference between a public library and a Chick-fil-A. I went to the Chick-fil-A over here over in the Five Forks the other day. In the Five Forks Chick-fil-A has a punch code to go into the bathroom. So I went in there, was going to go to the bathroom before I went to order my food, and I had to go order my food and wait on my ticket to get there before I could ever go into the bathroom because it contains the code to get into the bathroom. That's fine for them. And what they put up on their wall is fine. They're a private entity. They're not public monies going into that. One of the things that we know through law and through the courts that has taken place is that if we're spending public dollars, we also have the ability to say what those public dollars are going toward and what they're not going toward. And that's one of the things that we can take and do. It's one of the things that I have learned through my 35 years in public administration is that's one of the differences between private entities and public entities, is that we have the ability through our funding to take and make those sorts of decisions. Now, if we have applied, even though you may say that the schools are different and the libraries are different, they're both public agencies that we fund with public dollars. Yes, they are. They're both public. They're not public agencies?
They're
not public agencies. We not fund them with public dollars?
They serve different purposes, Mr.
Well,
Smith.
that's not the point, though, Mr. Rutherford. That's the whole point I'm trying to make to you. If you would just listen to me and let me finish up. If you look at the public dollars that we're spending, we have the ability to take and say how those dollars are going to be spent and what they can be spent for and what they're not.
Right,
and that's something we do all the time.
I agree. Here's the problem. Once you have allowed those public dollars to be spent on building an auditorium, you can't control what goes in the auditorium. That's
Absolutely
the problem. You can at a school, you cannot at a library. It performs a different function. And by the way, it was not the Chick-fil-A that had the art. It was the College of Charleston that had the art. Chick-fil-A doesn't have any art on its walls, just signs and posters. It was the College of Charleston that hung it. And so that's the difference. We can't tell the College of Charleston, we give them money, don't hang pictures with naked women in them. We can't do it because, again, there's something called the First Amendment. And the First Amendment protects even speech that we don't like. And speech that we don't like taking place in a public place like a library is going to be protected. And if you can show me case law that says I'm wrong, please do. But I got plenty of case law that says that what I'm saying means that your proviso is going to, or your amendment is going to cost us a bunch of money. That's all.
Thank you, Mr. Rutherford, but I definitely disagree.
Thank you.
Thank you, Mr. Smith. Thank you, Mr. Rutherford. Ms. Cobb-Hunter is recognized for a question.
Thank you.
Yes, ma'am, Ms. Cobb-Hunter.
Thank you, Mr. Chairman. And Mr. Smith, I'm not
Yes,
going
ma'am.
to try to belabor this. Just had two quick questions.
Sure.
Because you're throwing me off constantly referring to the standards, health, and those are curriculum standards. Are you aware of that?
Yes, ma'am.
And so I'm not clear on how you are expecting curriculum standards, things that apply to a school, why, and that's why I was so interested in Mr. Rutherford's line of questioning. But what I really wanted to ask you, because I hear your passion in, I'm trying to figure out how y'all are so selective sometimes. And my question for you is, I recall when Mr. Simmerl and Mr. Rutherford had a bill last week or week before dealing with the issue of tobacco.
Yes, ma'am.
As I recall your argument in opposition to it, you didn't think it was okay for government to be involved in that issue, but you do think it's okay for government to be involved in this issue?
No, ma'am, that's not what I said. I said that,
Okay.
what I said was I agreed with
Well,
what they.
local matters, I should say. Go ahead.
What I said is that I agreed with what they were trying to do. One of the things that I had a problem with was that when doing so, there was an unintended consequence, which would restrict the cities and counties from the ability to take and to apply zoning ordinances because of the wording in the bill itself that dealt with all ordinances and did not allow an exception for the zoning ordinance, which meant that a vaping shop, convenience store that allowed vaping, sell vaping products, could not be limited to, say, from not being in a S1 zone, which is a strictly single-family residential zone. That was my concern that I raised there. But thank you for bringing that up.
Thank you,
that
Mr.
helped.
Smith. And
Yes,
as
ma'am.
much to your chagrin now, I'm going to relinquish the chair to First Vice Chair Cobb-Hunter.
Thank you, Mr. Simmerl. Mr. Finley? Mr. Finley, did you have a question?
Yes, ma'am. What is the appropriate, is there an appropriate motion? Is it table or adjourn? We have other provisos. I'm happy to come back to this one, but I'd like us to. Be happy not to come back to it. That probably be the appropriate way until the chairman got back to
He is the chairman.
Well, for purposes, I know it's hard for you to accept this, but I am the chairman right now. Okay. I think Mr. Bales is about to offer something, Mr. Finley, that you would like. Mr. Bales?
Thank you, Madam Chairman. I thought I had
Pass over.
trained Gary while we were on the healthcare subcommittee, but today I feel like I've
Failed.
I didn't do too well. But I did try real hard.
And I think everybody give an A for effort.
But I would move to table this amendment, and we wouldn't waste no more time.
The chairman is back now. Mr. Chairman, there's a tabling motion by Mr. Bales on this amendment, but we did have some others who wanted to be heard, Mr. Stavronakis and somebody else on this row, and Mr. Moss. But there's a tabling motion on the floor, which takes precedent.
Mr. Bales, do you want to withdraw your table motion, or you insist upon it? Okay.
We love you,
I'm feeling the love, Mr. Bales, feeling the love. And with that, I'd ask for a roll call.
Okay, all right. Unless Mr. Bales moves to table amendment number 2, and Mr. Gary Smith asks for a roll call, so we'll proceed to a roll call. All right, the table in motion carries 17-5. We'll move on to the next amendment.